Hi everyone, and welcome to our webinar on unpacking the proposed EU AI Act. This is a part of a series of Policy Hour webinars that we host with leading people from the regulatory and from regulation, from law, from industry, who are interested in all things AI, regulation and policy. I think in a few weeks' time, we'll be hosting a webinar with a colleague of ours in the United States. So we're very much interested in what's taking place in Europe, as well as in the UK and in the United States. But today we'll be focused very much on the EU AI Act. Just as a kind of way of background, my name's Emre Kazim. I'm co-founder and co-CEO of Holistic AI. We're a platform provider of AI risk, governance, and compliance. Our mission, if you will, is to empower enterprises to adopt and scale algorithms with confidence. We're working across a whole host of sectors, from CPG to HR to insurance to financial services. We've seen a huge explosion in the adoption of algorithms, and with that, all of the kind of governance questions that come along with it. Just as a kind of a foreshadowing of Minesh's section, we're really pleased to have Minesh with us today. Minesh Tanna is a partner and global AI lead at Simmons Simmons. He's an expert who regularly advises clients on ethical, regulatory, and legal issues relating to AI. He's also the chair for the Society for Computers and Law, an AI group, and he frequently writes and lectures on AI law, and he has a particular expertise in the AI Act. I have to say I'm really excited, and I just have to thank you so much, Minesh, for doing this. Real pleasure to host you today and have you speak, as you're a great authority in this space and a source of truth.
Thanks, Emre. Very happy to be here. And as someone who's losing their hair, I'm happy to see that you've given me an Elvis-style quiff on the slide as well. So,
oh God,
thank you.
Yeah, thanks, Minesh. We're all getting there slowly. So I'll just set the scene. This is very much the way we're going to host this webinar is that I'll set the scene, just spend maybe 1 or 2 minutes on that, and then really going to hand over to Minesh, and then we're going to have plenty of time for question and answer. Some people have already written in with lots of questions. We've had lots and lots of interest in this space, and I think it's really just the beginning. We've got over 100 live attendees now, so lots of interest in this space. So I'll make sure that we've got lots of time to ask questions. So just setting the scene, if you will, is what's motivating this. So myself and my co-founder Adriana Koshiyama, we were academics in the computer science department of University College London. And when we first got going on the problem, if you will, of trustworthy AI, it was a computer science problem, if you will. And people were saying, how can we be confident that the algorithms are working as we intend them to work? So really the questions were around reliability, robustness, these kind of questions. Explainability started becoming a thing, but it was explainability from very much a technical perspective, and less so on these kind of things like bias, for example, and really not so much in terms of the novel problems that AI introduces to privacy itself. So that was going on to 2017, 2018. And people are often saying, what changed? Was it this kind of adoption of these algorithms, etc.? And I think probably the most important thing is that we had huge incidences of AI harm. So, let's take an example. Usually people are concerned about issues of algorithms being used in ways that are unfair. Sometimes these algorithms are targeting people in ways that we don't accept as a society. But there's also these other examples of algorithmic harm. So you can see this example of Night Capital, which was a trading algorithm which glitched. And in a millisecond, it lost the company $440 million. The company went bankrupt. And we've got other examples, wave after wave of examples of where algorithms are being used by industry and they're causing harm, and it's causing this issue of algorithmic adoption and harm to become an issue which was peripheral to becoming a kind of what used to be headline of the month, became headline of the week, is now headline of the day, and then it's how many things have happened today. So we've seen this kind of real tsunami of these kind of incidences of AI harm that's really motivated the kind of public concern, and this has precipitated the kind of regulatory interventions. So with respect to regulation, and I'm not going to go into it because really Minesh is going to do a deep dive into the EU AI Act, it's good, I think, maybe to also put this into kind of global context. So we do a lot of activity in Europe and in the United States, just got back from the States. And what we're seeing just on the United States side is a whole raft of regulation and proposed regulation in the EU, both at the state level and at the federal level, and in different sectors. So sometimes it's kind of sector agnostic. So we saw the proposing. I'm sure it's not going to be passed, but bits and bobs of it might be cannibalized and put into other regulation of the AI accountability, of the Algorithm Accountability Act in Congress. But we've also seen at the state level, Colorado mandate bias audits for algorithms in the use of insurance. And we've seen, of course, the New York City bias law for the use of algorithms in recruitment. But we're seeing lots and lots of activity in this space, and it's really heating up. Here in Europe, we've got the EU AI Act, which Minesh is going to present today, but it's just to also put it in the context that we could have spoken about what's taking place in China. We've also got lots and lots of activity. The UK published their white paper in AI regulation about a month ago or so. So really, there's a kind of global movement here. And I think what we anticipate, and is something I would love to ask Minesh about, is in a way the kind of legislation, the kind of gold standard is probably likely to be the EU AI Act. So it's really important for us to focus on this and really get a good knowledge of it. So I'll pass over to Minesh. Minesh, please do also introduce yourself if you feel I missed something, but I'll leave it to you. I'll hand it over to you.
Thanks, Emre. You did a sterling job in introducing me, so I don't think I need to say anything more. Just to reflect on a couple of points that you mentioned, as you say on the slide that you were just speaking to, there is now a trend towards global regulation of AI. And what I mean by that is not harmonious regulation across the world, but regulation being proposed in various jurisdictions. But I think there was an interesting announcement by the FTC and a few other regulators a couple of days ago, really emphasizing that actually existing regulation can still be used to enforce against AI and to regulate potential harm that AI can cause. So I think that's going to be an interesting factor to consider over the next few years as well. I mean, we've seen, for example, data protection authorities already flex their muscles with regard to AI use. And I suspect we may see a bit more of that. And that will, I think, sharpen the focus on exactly what we want AI-specific regulation to be covering, the more we see existing regulation actually being used effectively against AI. So I think there's an interesting debate to be had there as well. But you've invited me along kindly to talk about the EU AI Act. And I just want to cover a few points on that today before we open it up to the floor. I'll start off with an overview of the Act. I won't spend too long on that because I suspect a lot of people now have a good understanding of it. It's over 2 years since the European Commission published the first draft of the EU AI Act. So it's been around a while. I will talk about a few issues that the European Parliament is currently grappling with, particularly around foundational models, and some of that has just been happening in the last few days. I'll then briefly cover some important, but I say hidden, they're not hidden, they're obviously in the AIA, but they are, I think, understated and perhaps not given the attention they deserve. We'll have a look at a couple of provisions in that regard, and then very happy to take questions, and Emre, you and I can discuss any points that have arisen as well. So let me start with an overview. As I say, apologies to those to whom this is very familiar, but we are talking about the first comprehensive legislation globally which specifically covers AI, and it is a piece of horizontal legislation. It's not vertical in a similar way as we might see in the UK, for example. We know that the UK is generally going to have a pro-innovative regime, which I think we can translate as light touch, non-binding regulation, at least in the short term. But the other aspect of it is that it will be sector specific. So we're talking more vertical, whereas the AIA is horizontal. It has a very wide definition of AI system. I think that was deliberate. The Commission wanted to future-proof this technology against developments in the future. It is, however, very wide. I think a few of us joked at the time that it could cover Excel spreadsheets. I think we are looking at probably a narrower definition in the final version, but still TBC. There are strict penalties. And I think this really shows how serious the EU is about regulating AI. It's similar, if not higher, than fines that we could typically see under the GDPR, so up to 4% or 6% of a company's global annual turnover, so that's significant. Timing-wise, so we had the Commission draft, which was the first draft to come out in April 2021. We then had the European Council draft in December 2022, and the European Parliament is now looking at its proposals and amendments to this. And as I understand it, there could be a vote as early as 11th of May for the Parliament draft. think that may get pushed back a little bit, but let's see. And then once you have effectively the 3 drafts, you move into a process called the trilogue discussions, where the institutions will thrash it out and hopefully come to an agreed final text. And we're looking, I think, perhaps optimistically, at late 2023 for the passing of the Act. There's then a 2-year grace period, so there is still a bit of time. I think the European Parliament will be worried about how quick the technology is going to move again during that 2-year grace period, because they've had the slightly unenviable task of working out how this regulation is going to deal with foundational models, particularly given the recent hype around ChatGPT. Now, an important point is that even though it's an EU instrument, it is extraterritorial. That means it can apply to organizations outside of the EU. The slightly easier criterion is that if an organization outside of the EU supplies an AI system into the EU, it will be caught. The slightly less certain criterion is that if you have an AI system outside the EU whose output is in the EU, you might also be caught. Now, you'll be forgiven for questioning what exactly that means, and I suspect we're going to need a bit more guidance, because it's certainly not crystal clear from the face of the Act. Now, the final point I want to make just before we move on is that it's important to understand the context around the AIA. It forms a part of the European Union's product safety regime. And way back in 2008, there was something called the New Legislative Framework, which laid down harmonized standards and strict procedures for goods coming into the EU. And if you've ever seen that CE mark on a product, it means it's gone through this process, because the EU wants to have high standards for goods and services coming into the country. And the examples I typically give about this product safety regime are machines, toys, and medical devices. And I think the EU perhaps is starting to see the slight weaknesses in treating AI in the same way, and we'll come on to look at exactly why that is in the context of a few particular provisions. But it's really, I think, helpful to look at this through the lens that the EU sees it, which is as another product, and that this Act is really about product safety and protecting consumers. And if you see it through that lens, you start to understand a bit more about the rationale for some of the provisions and how they operate. So, just moving on to the structure of the AIA, it adopts what we call a risk-based approach. And I won't go into too much detail, because I think, again, most people are probably familiar. There are prohibited AI uses. Those are still under discussion. I understand the European Parliament is still discussing those, in particular around facial recognition. There was a lot of attention, if you remember, a couple of years ago about facial recognition. There were lots of people calling for an outright ban. At the moment, it's much narrower as a prohibited AI use, but that's still up for discussion. The bit I want to focus on is the middle bit, because that really is the focus of the AIA, and that's high-risk AI systems. And there are 2 sets of provisions to look at. Annex 2, which is a lot of those products I was talking about already covered by product safety regulations, so medical devices, machines. If an AI system is associated with those, there's detail around this, but I won't go into it. If an AI system is related to those, then it's considered high risk. The slightly easier, more comprehensible list is the Annex 3 list, which sets out various uses and domains, and in some cases types of AI systems, or biometric AI system, which will be considered high risk under the Act. And I think Annex 3 is going to receive a lot of attention. There's still a bit of discussion about what the final list is going to look like, but that's really the focus of the AIA. And then I've put the word providers in slightly larger text than users. And coming back to, again, product safety, the EU puts generally all the burden, the regulatory burden, on providers, on developers. Because if you think about something like a medical device or a toy, it's the developer, the manufacturer of that knows about it. It knows how to make it safe. It's not the consumer, the user, that should bear the regulatory burden for making it safe. So again, looking through that lens, it's unsurprising that the AIA has placed significant burden on providers. And then if we go on just to look at what that burden is, it is a significant burden. So this sets out just a snapshot of the obligations that a provider of a high-risk AI system will be subject to. And I won't go into detail, but you can see from a few of those headings how onerous this is. And actually, if you speak to data scientists and machine learning engineers, they look at some of these provisions and actually that they say that these are really difficult to comply with. I mean, the provisions around data and data governance are strict. There are whole regimes around putting in place a quality management system, a risk management system, a post-market monitoring system, really burdensome stuff here. Now, there's detail in the AIA, but actually what we now know is that there are going to be technical standards that are going to set out more of the detail about what exactly each of these requirements needs. And recently the European Commission has tasked two bodies, CEN and CENELAC, to start working on the standards that will underpin these requirements. And those will play a vital part in allowing organizations to understand what's required and how they can comply. The timings are going to be a bit odd because I think CEN and CENELAC have a big job on their hands, and I think they're looking at 2025 before they can really bring these out. So that's probably halfway through the implementation period. So it'll be interesting to see how organizations react in the first half of the implementation period. But let's not take anything away. That's a huge task that they've got to play. And then the final, sorry, I just need to go back one slide if that's possible. The final point I was just going to make, maybe we don't need to, I just clicked ahead, unfortunately, but it was, there we go, thank you. Just understanding the wider context, it's not just the AIA that we're talking about. So after that was published, quite recently, we had two other proposals from the European Commission, which I think are related in a way. So we had the Product Liability Directive amendments, and you're probably familiar that there's already a product safety regime in the EU. It's a strict liability regime. Sorry, I think we've gone, there we go. That one. One more. I'll keep going, but yeah, so there was already a strict liability. There is a strict liability regime for loss caused by products. It was unclear whether or not software and AI systems would fall under that. The proposal is now to make it expressly a part of that regime to have AI and software. Now that's principally for physical harm, but there's also a proposal to put data loss in there. The other interesting proposal, again from the Commission, is an AI liability directive, and that's supposed to work hand in hand with the AIA. So if you think about the AIA as being more about preventing harm and ensuring good governance in the development of AI models, the liability directive is more about providing effective redress when AI goes wrong and causes harm. And I think one of the most interesting parts of that directive is an express recognition that class actions can be brought when AI causes harm, and that's not limited to physical harm. So that could be, for example, discrimination. So it'll be interesting to see how that plays out. There's obviously a legislative journey for those two acts as well, or instruments. So it'll be interesting to see how they play out. But the EU, as you can see, is really serious about regulating AI in different ways. So moving on now to the European Parliament and the issues that it's facing. So as I said, it's the Parliament that's now looking at the AI Act. And I think the biggest challenge that they have faced is around foundational models, or as the European Council, I think, was trying to cover them by, general purpose AI. And I have to take you back to the value chain for this. Now, I think it's quite artificial to see AI as analogous to machines and toys, because as you know, when an AI system is supplied to another party, that party can then do various things with it. It might be supplied as a foundational system, for example, a large language model like GPT or Lambda by Google, and then the next party along will use that and fine-tune it, train it further, give it a specific purpose. Now, I think the Commission draft really failed to understand that this is how AI can work in the value chain, so it didn't really pick up on that. The European Council attempted to deal with it by introducing this concept of general purpose AI, and I've put the definition on the slide. Now, I think that was really difficult because if you think about the AI Act, it's looking at regulation through a risk and a use case based approach. rather than seeking to regulate the actual form of technology. There's obviously a definition of AI system, but it's not seeking to actually regulate the technology for how it's used. But actually, when you start thinking about general purpose AI and foundational models, you're now looking at the actual technology itself. So this was always going to be difficult for the European Council. And with all due respect, I don't think the European Council's proposal is very easy to follow. Particularly in terms of that value chain. What happens when a foundational model comes out of a big tech company, goes to another party and potentially even another party? How do you allocate the regulatory burden in that value chain? Now, I think thankfully, the European Parliament is actually just recognizing that we are going to regulate the actual technology. So as I understand it, the current proposal is to have regulation of foundational models, and that's going to be irrespective of how they're ultimately used and ultimately what risk they cause or could cause. So really getting away from the original risk-based approach and looking at how it's going to be used, the purpose, and actually just regulating the technology. There's going to be specific regulation, I think, of generative AI models in particular, and particularly around copyright, I think, which is a sensitive area there. And then there may be some provisions around GPI. So for example, if you had a facial recognition system that is developed by a provider of facial recognition systems, they don't ultimately know how that's going to be used by the end user. So in those circumstances, it's not fair to put the entire burden on the developer, which I think is finally now being recognized. So there needs to be some sharing of the regulatory burden there between the developer and the final user that actually decides what purpose to put that facial recognition system towards. So there may be some provisions around DPI, but I think that's going to cause quite a bit of discussion. I think that'll be a focus for the trilogue discussions. And all I would say is watch this space. I'll just briefly cover a few other issues that the Parliament is grappling with. As I say, they're still discussing prohibitions. We're hopeful that we'll get a narrower definition of AI because I think as it stands, it's very wide. There's talk of a potential qualification for high-risk systems. So even before you get to the Annex 2 and Annex 3 list, a qualification that it'll only be high risk if it poses a significant risk of harm to health, safety, or fundamental rights. That may be sensible. I suspect it will add a bit of uncertainty as well, but let's see. The really interesting point, and I think this may have been resolved, but we won't know until we see the final Parliament text, is the potential for having provisions around general principles. So similar to what we've seen in the responsible and ethical AI world, so principles around, for example, transparency, security, human oversight. I find that a little bit strange because for me, the whole point of regulation is to capture a lot of those principles and then give, effectively regulatory flesh to those principles. So I still find it odd that you would then include the principles in the final regulation. I guess the idea is that they would apply to low risk AI systems. But again, let's see what happens with that. It may not make it into the final version. And then the final bit I wanted to cover was just a couple of, as I say, underappreciated provisions in the AIA, which haven't received much attention. Now, coming back to value chain, as I say, the EU wants to put the burden on the provider, but then we see Article 28, which says that any distributor, importer, user, or other third party, so all the other people in the value chain, shall be considered a provider for the purposes of this regulation, and therefore subject to the obligations of the provider under Article 16, that's the high-risk burdensome obligations that we just looked at, in any of the following circumstances. And actually, one wonders, are these going to be triggered more often than the European Union thinks? Companies may put into service a high-risk AI system under their own name rather than in the name of the provider. They may well make a substantial modification to the high-risk AI system. All of those are possible. But think about the implications of that. You've then got a user, and albeit they're not, a lay person, it might be a sophisticated organization that knows what it's doing, has, a lot of AI going on, but it's then in theory supposed to be subject to obligations around training and data. And I just think that really hasn't had enough attention because I'm not sure how providers later on in the value chain are necessarily supposed to be able to comply with that. So I suspect we'll see a bit more attention on that provision in due course. And it does overlap with the regulation about foundational models and GPIA because, again, you've got to look at the value chain when you're dealing with those inherently. So that's one. And then the other one is the so-called grandfather provisions. And again, not You have to read this a couple of times just to get it. But effectively what it's saying, and it's about high-risk systems specifically, my interpretation at least, is that the regulation's only going to apply to high-risk AI systems that are effectively, and these are European Union concepts, but made available on the market or put into service after the AIA comes into force. However, it could apply to existing high-risk AI systems if they are subject to significant changes in their design or intended purpose after the date the AIA comes into force. Now that's interesting. You know, I've been wondering, is there going to be a mad scramble to get high-risk AI systems placed on the market or put into service before the AIA comes into effect? So actually, you don't have to comply with the obligations. And then you've got to wonder, what does it mean when a system is subject to significant changes in their design? I mean, if you update the model to deal with model drift, concept drift, you've got better ways of tackling bias. Is that going to be a significant change? Definitely some uncertainty around that. I think, Emre, that was all I wanted to cover. So thank you. And obviously, I can see questions trickling in. Very happy to tackle those. I hope that's given a bit of an overview and an insight into current discussions and some of the key issues, I think, that remain to be resolved.
Awesome. Thank you so much. As you said, there's plenty of questions already in. Also, lots of people wrote in actually with questions. I'm going to take the liberty of asking you some questions myself.
Sure.
Some points I wanted to just. I think the first one is a little bit speculative, which is, you know, you're talking about it being extraterritorial, and at the same time talking about, look, there's just so many moving parts here in terms of different aspects of the regulation and its scope. I think there's two questions. One, I wanted to ask you if there was, so your interpretation of the kind of the general force of it is that it comes from product safety regulation.
Yeah.
So if I understand it, it certainly does. But I thought it was part of, I thought another aspect of it was that it's part of the kind of general digital regulatory agenda. So like the DMA, the DSA, and the AI Act working together, if you will, to protect citizens. For anyone who doesn't know, the DSA is Digital Services Act, DMA is Digital Markets Act. And with that kind of view, it would then, if it will be more about, it would be not only the providers, or you provide this documentation, but the burden would be heavily also on the deployers of these systems or the users of these systems. I wonder if you could say something about that, Minesh.
Yeah, I think that's another way of looking at it. And certainly when you look at the EU's digital package of regulation, it would be remiss not to include this particular regulation. But I think what was interesting about this when it came out is that it wasn't directed necessarily at big tech, whereas, you know, the DMU is about competition, the DSA is about those large online platforms, and it's about content. It really was looking at large organizations, whereas you could have a small provider of an AI system which is used for recruitment purposes, for example, and that would be caught by the very burdensome provisions under the EU AI Act. So it's slightly different in that respect. But I think what's interesting is now that we're likely to see specific regulation of foundational models in the AIA, I think suddenly big tech will be brought into it, because it's usually big tech companies that are developing foundational models. But I think it's worth looking at it alongside the DSA in particular, which does cover algorithmic systems. And I think the big area of overlap is transparency. So the DSA requires risk assessment and transparency in relation to certain algorithms. If you're, I won't get into detail, but if you're designated, and I think that's going to have some overlap because there are transparency requirements under the AIA as well.
Just also adding to that in terms of the burden on the deployers, the users of these systems. Again, so is the idea, Minesh, that, you know, they've received, you know, we get our phone, we pick up our, you know, and we get that little document inside with the CE mark and all the kind of on how it should be used, etc. And then if something goes wrong, it's the provider, right? But where is the liability on the users of these systems? So to give an example, what if you're a big company and you've adopted a system in HR, part of your graduate recruitment program? Does it look like, I know this is pre-regulation, does it look like the liability is, even if you've got your documentation from the provider, there's still liability on the users of these systems in a particular way?
Well, I think you've got to unpack liability there. When we're talking about liability for non-compliance with the requirements of the AIA, that's
Okay.
still very much in provider territory. Actually, users are subject to a very light touch regulatory regime under the AIA. So that's still on providers. But of course, if something goes wrong with the AI system under the user's custody and control of it, for example, then there will be other instruments that will kick in. And that was, for example, reference to the AI liability directive, the product liability directive, and then national legal systems will have their own regimes for dealing with losses caused by the AI going wrong. And that may be more on the user. The interesting bit we haven't talked about is contracts are going to play a huge part in this as well. And obviously contracts are very useful instruments to share risk and allocate liability. So I suspect there will be some interesting things happening in the AI contracting world in order to share responsibility or allocate responsibility for compliance and AI going wrong. That's a whole nother area.
So one of the views, we were over in the States and people were saying lots of questions around New York City passed legislation mandating audits in the HR tech space. And I was just talking more, not so much specifically about that regulation, but more generally with some of the federal regulators.
Yeah.
And there was a sense in which you could never put this down in writing, if you will, but that, you know, as we initially start moving, a lot of the motivation is that people need to get their house in order. That at least until, because it looks like we've got years before we get these standards, before we get to the point where we've got a kind of coherent and articulated, if you will, criterion, that actually getting your house in. Is there any talk about the kind of impetus, the original impetus is really just to get a good risk management process in place?
Yeah, it's interesting. It comes back to that initial point I made, reflecting on the points you made at the start about whether existing regulation is actually going to be sufficient to mandate organizations to take certain steps. And I think it will to a certain extent. And I think we've probably all perhaps underestimated the extent to which existing regulation can deal with some of this. In the financial services sector space in the UK, there was a really interesting discussion paper that you may have seen, Emre, from the FCA, the Bank of England, and the PRA. And I think it was a very measured and sensible approach because it was exploring regulation. It went out to consultation. But one of the points made in it by the FCA and the BOE and the PRA was, first, we want to work out how existing regulation can cover this. Now, obviously, that's interesting in the financial services sector because there's a lot of regulation already there. But actually, we've got competition law, we've got consumer protection law, we've got data protection law in many jurisdictions. And actually, we're starting to see that regulators can use the teeth in that regulation against AI, the ChatGPT example being a good one most recently. I think to answer your question, I think regulators will probably start mandating and looking at organizations to implement governance in order to comply with those obligations. I mean, just to carry on, in the GDPR, you've got principles of transparency and fairness and accuracy, and a lot of those relate to AI, and a lot of AI processes personal data. So you can see how regulators will be expecting certain governance in place to comply with those principles.
I mean, I just wanted to ask, so it's picking up on one of the questions here that someone was asking regarding that implementation period.
Yeah.
I wanted to ask maybe, so just a little bit about a question I had. I think it's a conversation we had a few months ago in a conference in London about, am I misunderstanding that they can introduce implementation acts for particular parts of the regulation? Or like, how does that work, Minesh, in terms of, is it a staggered implementation, or there's like some kind of cliff edge where everything then is, so could you speak a little bit about that?
Yeah, I haven't looked at this for a while. I mean, I think that there may be an element of gradual implementation, but I think the majority of the regulations, and a lot of us look at the high risk obligations and look at when they're coming into force. And I think the main implementation period that's been, well, in the original draft, 2 years. There was talk of it being 3 years at one point in a few committees of the European Parliament. I suspect it has to be, well, I say that, I mean, I think a lot of people were saying you can't wait that long. We need regulation now, and who knows what the landscape is going to look like in 2 years' time. I'm not that cynical. I don't think we're obviously going through incredible advances, but I don't think things are going to be that different in 2 years' time. But don't quote me on that. Maybe that's completely wrong.
Yeah, maybe we have general intelligence by then.
Exactly. Yeah.
Turn off everything.
But the standards are so vital, and it's going to take a while for those to be introduced. So you can't really have, for example, a 1-year implementation period without the standards, because that's just going to leave organizations completely lost at sea in terms of how to implement some of those obligations. So I suspect it will still be 2 years. Maybe there'll be some nuances about certain provisions coming into force sooner, but with the main high-risk AI obligations, which a lot of us are focused on, I think it will be the 2-year period.
A question, lots and lots of questions coming up because obviously we're based in the UK and but we're not part of the EU anymore, but very much following what's taking place in the EU AI Act. So let me state it from, imagine I was a company, Minesh, and I'm coming along to you and I'm saying to you, you know, could you give me some advisory, not in this context as a legal advice, but as a kind of more general advice in terms of, you know, what do I do as a multinational who's based in the UK, and there's a UK signaling that they're going to take a more liberal regime and a sectorial approach. But then we've got this kind of behemoth here, where, as you said, it's extraterritorial. Without doubt, we're going to be operating in that context. Is the rational move just to simply be conforming to the EU AI Act, as it's probably more burdensome, and then taking that as the kind of gold standard? Or does it make sense for us to say, hey, we need to actually think this is giving the UK a competitive advantage?
Good question. And all the questions that are coming around that are very good. I mean, from a sort of normative perspective, I would say it's worth complying with the EU AI Act, but let's just break it down. And I speak to a lot of international organizations about this. If you've got parts of the business that are going to be subject to the AIA, then it may be slightly strange, inefficient, not worth it to make your UK parts of the business that are dealing with the same AI systems and attempt to make them subject to a lighter touch regulatory regime. I just don't see how really that's going to work in practice. The other point, of course, is the extraterritoriality. So it may well be, particularly on the developer side, provider side, that you're subject de jure to the AIA anyway. And then I think finally your point about gold standard is a good one, because even looking back at the UK's white paper, even though it's very light touch and we're not probably going to have binding regulation for a while, it still says that organizations should comply with various principles. And those are the usual principles that we see in this space around responsible and ethical use of AI. And actually, when those standards come out, you're going to have a roadmap in the AIA for complying with those principles. So I would be probably saying to organizations, you've got guidance there on how to implement them, so why not comply with those anyway?
A couple, I think, just another quick question now, because we've got a lot of questions people asking. There was a more specific one about, and it's something we're certainly interested in, financial services and insurance sector in the UK. So that's where, you know, really there is a huge weight outside of Europe, you know, a real kind of advantage here in London. Do you think that in particular sectors, then it does make, well, not that it doesn't, not from a normative sense, as you said, but from, let's say, a strategic way, that there probably is going to make, there will be sector specific, if you will, interventions that are meaningfully diverging from the EU, even in terms of the level of burden?
Yeah, I think so, because actually when you look at the AI Act, it doesn't have that much application in terms of the high risk regime, at least to the financial services sector. There are a couple of provisions in there. So AI systems used to evaluate the creditworthiness of individuals. That is a high risk system. I imagine many banks, financial institutions are using AI in HR recruitment type purposes, and there may be others, biometric systems, for example. But actually, it's probably going to be the health and life sciences sector, for example, that's going to be most affected by the AIA, given that that's very much high risk under that. So I suspect there will then be increased scrutiny of what regulation there needs to be in that specific sector, and we may well see more targeted regulation there. I think, you know, the FCA, BOE and PRA are obviously looking at it in the UK Let's see what happens there. But even in the EU, we might see something, and a lot of the policy groups are in that space have started to make noise. But I should say the Commission is empowered to change that list in Annex 3 and make things high risk. And I suspect there may be some noises about making more AI systems in the financial services sector part of that high risk regime in the future.
Yeah, just another quick one on that. So is it right to say, Minesh, that so the list is non-exhaustive, and the caveat that you said that they're thinking of putting in terms of it has to have sufficient impact, negative impact, or risk for it to be considered high risk. One way I used to read it, and I'm not sure if this is the right way of reading this, is that the definition was that it gives you the general characteristics of what would be considered a high risk system, rather than qualifying the listed high risk systems in terms of the context of use of those kinds of systems in insurance, in employment, in security, etc. So that it was kind of doing both work, that the list was an indicative list, and this definition was about the characteristics of the kinds of systems which may be present outside of that list of listed high-risk systems.
Yeah, I think that's, I mean, as I read it, and again, it depends whether you're looking at because Annex 3 is clear in one sense, but confusing in another sense, because it refers to types of AI system in some places, so biometric AI systems, and then domains or areas of use. So, for example, recruitment. But I think it, as I understand it, it's all about intended purpose as well. That's quite an important concept under EU legislation generally, but under this as well. So, if your intended purpose is to use the AI system in recruitment, then you are going to be subject to the high risk system, as long as it's an AI system. Of course, that's the gateway. It's got to be caught by the act in the first place. And if you've got a biometric system, and query whether there'll be discussions around precisely what that means, but hopefully that's clear and there's obviously guidance from the GDPR on that, then equally you'll be subject to that Annex 3 list. But maybe I need to go back and have another read, Emre. It's been a while since I've looked.
No, I think it was. It also could be a kind of a bias in my reading, because it just felt so Anglo-Saxon to give lots and lots of examples at the end of the legislation. I just thought, aren't we supposed to be reading EU legislation with different eyes? I always thought they would come with a kind of definition, and that these systems might just be examples, but actually. So a question is coming up time and time again in different forms in the different questions here I can see in the box. It's about innovation. So I don't want to state this. So I think this, if I may, two parts. One part is I know that that they talk about innovation and they make provisions for small companies, and they say we don't want to be hindering regulation. Of course, that's avowing something, because it may be different in practice. And that's probably the second question. So the first question is what is it? So yes, it makes provisions for innovation and small companies. So maybe you could say something about that.
Yeah.
But then secondly, actually a kind of interpretation, maybe, of is there a sense in which this, so the fear, if you will, in industry is that this is really going to kill innovation. The burdens are just so high. You're better off doing everything in the United States or other jurisdictions. So two sides to it. One, in terms of what is actually, is it broadly, what does it say? And secondly, what's the how should we interpret this?
Okay, so on the first point, it doesn't actually distinguish as much as people would have hoped between large providers and small scale providers. There are certain provisions that are aimed to support innovation. There are provisions around sandboxes, and I think it was Spain that was the first country to start actually thinking about that seriously, which was good. I think, as we've seen with the Parliament, and I keep coming back to, there may be a bit more regulation now for big tech who are developing foundational models. But I think, unfortunately, if you're in the high risk category, for example, then irrespective of your size as a provider, you are going to be subject to the high risk obligations. There are no de minimis exceptions from that, for example. And so you're right, Emre. I think when this first came out, there was vehement criticism about its extent and the fact to which it could stifle innovation, because it just imposes a significant regulatory obligation. I have to confess, I was probably in that camp at the time, thinking, this isn't good for innovation in the EU. And as you say, the US is going to take over. we're in a different world. I mean, it's only 2 years on, but it really does feel like we're in a different world where even AI developers themselves are calling for regulation, because a lot of it's about trust, isn't it? We now see AI in our lives. ChatGPT has done that. We've seen it go wrong. And so I think there's a sense of, well, AI is here to stay. It's going to be in our lives, but now we really need to make sure that we trust it. And actually, developers are now seeing that as a positive thing. So if they can show to society that they're developing models responsibly in a way that they can be trustworthy, then actually that's going to be better for them. And I've always said, AI governance is not just a defensive negative mechanism. It's not just about doing things to make sure you don't get fined by a regulator. It has positive implications as well, and it can give you commercial advantages. So I think I'm probably in a different camp now where it may affect innovation a bit, but actually it lays down governance that's needed. I'm sure there are still debates to be had about, does it go too far in certain respects? But actually, I think a lot of jurisdictions are probably looking at the EU and thinking they did the right thing. They foresaw all of these issues that were going to happen with AI, and they did the right thing in laying down strict regulation.
Yeah, I mean, it's chaos now, right? People are deploying these powerful systems. Not just some chatbot. Sorry, what's this? A chatbot? Not just some kind of spam detector or something that generates a word cloud, but really, really powerful systems, and they're being kind of used across industry and society. So there is that impetus. And how I kind of what we notice is this kind of precipitation off the back of these really high-profile cases of harm. And more and more, when we first used to get going and asking people about AI, it used to be kind of science fiction-esque. People started talking about the Terminator, somehow, ambiguating robotics and AI. And now it's actually real, tangible examples. So yes, it's a kind of mediation of that worry and that fear. Minesh, wanted to ask, so there's been quite a few questions about the transparency requirements. So let me, use it's an anonymous question here, so I'm not sure what the motivation behind it was, but I understand there are low risk systems. So I'm going to ask first the kind of technical side, which is, it seems a little bit strange to me that you would have an obligation, so your requirements, your regulatory, your compliance requirements are on high risk systems. But wouldn't that require assessing all systems to know whether or not they're high risk?
Yeah, definitely. The actual process that you go through, and if you were to map this out in a decision tree or flowchart, it's complex, right? This is a really complex piece of regulation. So you're absolutely right, Emre. I think one of the first things that organizations will need to do is work out if and how the act applies to them. And there's going to be uncertainty about that, right? Starting at the very top, do you have, or are you involved with an AI system? And there are going to have to be some difficult calls to be made about whether you are genuinely dealing with an AI system as defined, or whether it's more like an expert system, as you probably started out life dealing with in that world. And then you've got to work through. And the key question, I think, will be, are you subject to the high risk regime? There are transparency obligations for other uses and AI systems which fall outside of the high risk system. That's in Article 52 of the Commission draft. They're quite discrete. As I say, I think the real focus is just on high risk uses under the AIA. It feels a bit patchwork outside of that, a few prohibitions, a few other systems that require transparency obligations, and then other systems where you can voluntarily comply with codes of conduct. It's a bit patchwork. So it's really the high risk AI system that's the big one.
Regarding, just continuing with that theme about the transparency obligations, this has been a pet peeve of mine. Is it going to be that I know the obligation is that you should be informed that you're interacting with an algorithm this is on transparency in the end with the end user in mind.
Exactly.
How do you see that playing out? Do you think it will be through kind of permissions consent like we got with the cookies? Could you speak a little bit about that?
I mean, I suspect the EU will want to see tangible, meaningful efforts made to communicate that this is really an AI system that you're interacting with. I mean, I don't know if it's necessarily analogous, but I think about informed consent and the principle of under the GDPR, where you can't have frivolous or woolly consent. It's got to be, meaningful. And I suspect the EU would take a similar approach to transparency as well. You've really got to make it clear that this is an AI system that end users are interacting with.
So, there's a much more practical question as we move towards the end of the webinar. So you're a company, you're sitting there thinking, God, I don't even know how many systems I'm running, and where do I get going? Like, what are the practical steps that I can start taking to start thinking, God, let's get ahead of the curve here.
Yeah, and just before I answer that, I think I'll call it an issue, because I think it is a bit of an issue that we're seeing, is where does responsibility for all of this lie in an organization? I mean, take a bank, for example. They've had models in place for a long time, right, with high frequency trading and lots of other uses. So a lot of banks have model risk governance teams, and they will be looking at this, I'm sure. But then, this is going to be a regulatory requirement. It's about compliance. So suddenly you have lots of different teams with an interest in this. I mean, personally, and maybe I'm biased because I'm a lawyer, but I do think that this is a legal problem. So I think it should be lawyers driving this and protecting the organization the same way they do from legal issues that they're exposed to or could be exposed to. In terms of what you do, and maybe this applies irrespective of who it is within the organization, I always say that good governance in AI starts with knowledge. And that means both understanding AI, and there's always some trepidation about venturing into AI world because it is complex, but I would say, take baby steps. It isn't as complicated as you may think, but more importantly, knowledge about your own organization's use of AI. That even if it's as simple as starting an inventory on, a spreadsheet, for example, just getting a sense of where AI is used in your organization, and particularly for big organizations, it's probably more widespread than you think. And then you can also look at things like how you're defining AI. And I think once you have a sense of where it's being used, then you can start to think more about risk assessment. And that includes risk assessment under the AIA. So you can look at each use case and work out how it's going to be treated under the AIA. And then the final component is compliance, and actually implementing measures to ensure that each of those use cases is being used in the right way and importantly complies with any regulation that applies to it.
With the I know it may be a bit tired to keep kind of making the comparison with GDPR, but what we saw with GDPR is the emergence of a new role, the kind of data protection officer. Do you see something like that emerging in the AI space?
Yeah, I do. And actually, the one point I should have said about where does ownership, responsibility sit within an organization, I see quite a few organizations looking at AI through the data privacy function and through a data privacy lens. And that can be fine because, you've got good governance, hopefully good governance, good compliance steps in place there already. But I would say the risk is that you don't give AI its due merit in terms of the risks it could create compliance. It's not just a data privacy issue, right? It's wider than that. But I do think there are analogies to be drawn with data privacy, because if you imagine the world before GDPR, people didn't really understand what personal data was. It wasn't a thing. So organizations suddenly had to get on top of this new thing, get up to speed with the GDPR, and then implement compliance. And I think we're going through something similar with AI, and that we're going to have to get on top of it, work out exactly where it's being used in an organization, because there would have been personal data everywhere in organizations, and you have to get on top of that, and then start to think about compliance, then good governance around it. All I would say is, hopefully there's not, as there was with GDPR, a bit of a mad scramble when it came into force. And I think there's a lot of merit in getting ready early for AI, not least because of the way AI models are developed. And you've got to take steps early on at the training stage and the testing stage to ensure that you've got good governance in place later on when those models are being deployed.
Yeah, so it's just like there's just so many things taking place in terms of internally in organizations and who owns this. Something which I found very interesting is I noticed that the community of interest in Europe does come from the data protection ecosystem, but I noticed in the States it actually comes from the cybersecurity, if you will, community. And it'd be interesting to see what the kind of path dependency of that is in the long run. But yeah, Minesh, just wanted to open if you've got any kind of final comments before we wrap up the webinar. Anything that we should really be thinking about, or what we should kind of maybe things that we're not aware of that we should be aware of?
I guess just to reiterate a couple of points, which is I think the next 6 months are going to be quite exciting for the EU AI Act, if I may use the word exciting. We're going to see the Parliament draft fairly soon, probably in the space of weeks. Then we'll have the trilogues, and all being well, we'll have the final text adopted by the end of this year. And then we'll be looking at standards, we'll be looking at implementation of the obligations. And the second thing I'd say is it's never too early to start thinking about this. I hear a lot of clients say, well, it's, we don't even know what the final text is yet. It's not going to be that different from the text that we've got. And as I say, getting ahead with AI governance is a really good thing for a few reasons. Partly that model development process I mentioned, it's quite time consuming and it can take a while, but also you've got to get under the skin of this and really understand it, and it's not straightforward. And then the third reason is look at the pace of development in this area. I mean, I think we're probably not going to have the same rate as we've had just over the past few months, but it is moving ahead. So if you don't get on top of it now, particularly as legal risk compliance functions, there is a danger of having to play catch up in a pretty serious way later on.
Yeah, and even just from an economic perspective, I mean, my God, we saw the panic with GDPR.
Yes.
And people having to act so late in the game. Massive thank you to you, Minesh. Really appreciate this. I've been following your work for some time now, and it's just a real pleasure to hear you speak about this subject. And thank you everyone who's been listening in. We actually had, I think, over 400 registrations for this webinar, so like a huge amount of interest. Also, should just mention that our next Holistic AI are hosting another policy hour discussion. Our next one will be in May. I think it's May 17th. It's with the Equal Employment Opportunities Commissioner in the United States, a guy called Keith Sunderland. We're really excited. And he'll be talking about not just the New York City legislation, but more generally about the state of play and in this area, in this really important area of the use of algorithms in the workplace. So thank you, everyone. We look forward to seeing you there, and do add us on LinkedIn and do reach out if you have any inquiries. And thanks again, Minesh. Really appreciate this.
Thanks, Emre. Thanks, everyone.
Awesome. Thank you. Bye-bye.